This video is for educational purposes only and does not constitute tax or legal advice. If you own a home in Florida and your estate is worth more than a few $1,000,000, the Florida Homestead laws are either your greatest asset protection tool or the hidden landmine that blows up your estate plan. Most people are keenly aware of the real estate tax savings. That's fine. But today, we're going to go deeper because for high net worth families, the exemption is almost secondary to the protection and the transfer restrictions embedded in Florida homestead law. Florida's homestead laws have three distinct components, and most people conflate them into one concept. That's a mistake, especially at the high net worth level. Component 1 is the property tax exemption. Florida residents who own and occupy their primary residence receive a $50,000 exemption off the assessed value of their home for property tax purposes. The first $25,000 applies to all taxing authorities, including school taxes. The second $25,000 applies to non-school levies only. Now, at a $10 million estate, a $50,000 assessed value reduction isn't going to move the needle dramatically on its own, but it's cumulative and it compounds with the Save Our Homes cap, which brings us to one of the most powerful benefits in the law. Under Save Our Homes, once you've established homestead status, the annual increase in your property's assessed value is capped at 3%, or the Consumer Price Index, whichever is lower. In a market like Palm Beach County, where property values have appreciated 40, 50, even 60% over the last several years, that cap creates an enormous divergence between assessed value and fair market value. That divergence, that's real tax savings, year over year, compounding silently in your favor. Here's where high net worth families often leave significant money on the table. Florida has what's called portability, and it allows you to carry your accumulated Save Our Homes benefit from one homestead to another when you move. The technical term for this is the differential, the gap between your assessed value and the just value, and you can port up to $500,000 of that differential to your new home. Let me put some numbers on that. Say you bought your current home 15 years ago. It was assessed at $1.5 million. Today, it's worth $3.5 million, but your assessed value, thanks to the cap, is only $2.1 million. That's a $1.4 million differential, but portability caps at $500,000. So you transfer that amount to your new property. If the new home is assessed at $5 million, your portability benefit immediately reduces the taxable assessed value to $4.5 million at a combined millage rate of, say, 15 mils. That's $7,500 in annual property tax savings immediately in year one, and it compounds forward with the new Save Our Homes cap on the reduced base. One important caveat: portability must be applied for within 3 tax years of abandoning the prior homestead. Miss that window and the benefit evaporates. Now we move into what many consider the crown jewel of Florida homestead law for high net worth families, and it has nothing to do with property taxes. The Florida Constitution and statutory law provides that a homestead in a municipality up to 1/2 acre outside a municipality up to 160 acres is exempt from forced sale under process of any court. The only exceptions are mortgages, mechanics' liens, and superior creditors, such as the IRS. What does that mean in plain English? It means your primary residence is almost entirely shielded from judgment creditors. A plaintiff who wins a $20 million verdict against you cannot force the sale of your Florida homestead except for certain debtors in bankruptcy. For physicians, business owners, developers, and high net worth families with litigation exposure, this is extraordinary protection. And Florida has no dollar cap on it. A $10 million home, fully protected. A $30 million Palm Beach estate, fully protected, as long as it qualifies as your homestead under Florida. Again, except for certain debtors in bankruptcy. This is a primary reason that many high net worth individuals establish Florida domicile. When you pair the homestead protection with Florida's no income tax status and favorable trust laws, the planning opportunities are substantial. Florida's homestead laws impose restrictions on how you can transfer your homestead, both at death and during life. These restrictions are constitutional. They override your will, and they can override your trust if you're not careful. If you die leaving a spouse and minor children, the homestead cannot be devised at all. It passes to the surviving spouse as a life estate with a vested remainder in the lineal descendants. You cannot will it away. You cannot leave it to charity. The law controls the disposition. If you have a surviving spouse, but no minor children, the homestead can be devised, but only to the spouse, or with the spouse's written joinder in the deed. You cannot leave it to your children over a surviving spouse's objection. In blended family situations, a person with children from a prior marriage executes a revocable trust, pours the homestead into the trust, and assumes the trust controls distribution. In many scenarios, depending on the trust structure and how title is held, Florida courts have found that the Devise restrictions still apply. The interplay between homestead restrictions and revocable trust planning is nuanced and heavily fact-specific. Estate plans must adequately account for this, or it could result in years of litigation among beneficiaries. The fix is usually not complicated, but it requires deliberately structuring the plan around the constitutional restrictions, not ignoring them. A business owner, let's call him a developer, wants asset protection across his portfolio. He transfers his home into an LLC for liability shielding. Smart instinct. Potentially catastrophic result. Why? Because placing your homestead into a multi-member LLC generally destroys the homestead exemption, both the tax exemption and the creditor protection. Florida courts have been fairly consistent on this. The LLC is the owner of record, not the natural person, and a legal entity cannot occupy a homestead. Similarly, transferring your homestead into a standard irrevocable trust where you retain no beneficial interest can strip the exemption. There are structures that preserve the homestead status while providing protection and estate planning efficiency, including certain qualifying trusts and life estate deed structures. But they require careful drafting, and they must be specifically tailored to the Florida constitutional requirements. Here are 5 things you should be verifying or addressing right now. 1. Confirm your homestead exemption is properly on file with your county property appraiser and that it hasn't lapsed due to a trust transfer or deed change. Many of the clerks are extremely helpful with this process. 2. Calculate your current Save Our Homes differential. If you're considering a move in the next 1 to 3 years, understand your portability window and portability cap before you act. 3. Review your estate plan for homestead Devise restrictions, particularly if you have a blended family, a surviving spouse, or minor children. Make sure the plan accounts for constitutional constraints, not just your intent. 4. If your home is titled in an LLC or irrevocable trust, have a Florida attorney specifically analyze whether homestead status is preserved, and if not, understand what you've given up and whether the trade-off was intentional, as well as other risks that may arise by having the homestead owned by an LLC. 5. If you've moved to Florida recently and established domicile, make sure you filed the declaration of domicile and completed all the procedural steps. The tax and protection benefits are not automatic. Florida homestead law is one of the most powerful planning tools available to high net worth families in this state, and one of the most frequently misunderstood. The tax savings are real. The creditor protection is extraordinary, but the transfer restrictions are constitutional landmines that can unravel even well-designed estate plans if they're not addressed deliberately. If you want a Florida estate plan that actually works the way you intend, not the way a court interprets it after you're gone, you need advisors who understand the full picture. If you found this useful, subscribe to the channel and hit the like and notification button. This channel will publish educational content focused specifically on Florida estate and tax strategy for families with significant estates and business interests. And if you have a specific situation you'd like us to address in a future video, drop it in the comments. Until next time.